debate. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to be able to speak once again about Bill C-26, an act to amend the Criminal Code, citizens' arrests and defences of property and persons. I'll switch to Madam Speaker, I guess. I would like to begin by thanking the Justice and Human Rights Committee for its work in studying the bill. The committee held 6 sessions that were heard over 15 witnesses from outside government. The committee heard from a number of associations, such as several pan-Canadian groups, including, among others, the Canadian Bar Association, the Barreau du Québec, the Canadian Convenience Stores Association, the Canadian Police Association, the Canadian Association of Chiefs of Police, the Criminal Lawyers Association, and Canadian Association of Elizabeth Fry Societies. The committee also heard from a number of individuals, including David Chen, a local criminal defense lawyer, and several law professors. The diversity of witnesses who appeared at committee reflects the fact that the proposals in Bill C-26, though only a few pages long, touch a long range of issues that are important to Canadians. The committee no doubt benefited immensely from hearing the perspectives of specific populations such as police officers, small business owners and their families, the private security interests, and victims of domestic violence. The committee undertook a thorough and profound analysis of the legislation, which has implications not just for special populations, but for all Canadians. I would especially like to thank the committee and the witnesses who testified for their commitment to balancing the needs of victims of crime to respond to emergency situations on the one hand and ensuring on the other hand that the law discourages vigilante responses to crime and the escalation of violence and the abusive exercise of arrest powers. This is always difficult to balance, but at the same time, we believe that members on all sides of the House should wish to see this balance struck appropriately. The committee made several modifications to the legislation, which I will shortly address. I believe these modifications improve the legislation, and I would like to once again express my appreciation for the serious and professional manner in which all committee members approach these important and sensitive issues. Mr. Speaker, members will recall that Bill C-26 proposes a responsible expansion of the citizens' arrest power and also includes a long overdue simplification and clarification of the law of self-defense and defense of property. With respect to the power of citizens' arrest, the expansion proposed in Bill C-26 is modest and limited. No one disputes the fact that arrests are primarily the responsibility of the police. But in recognition of the fact that the police are not always present when crime is committed, the Criminal Code has long authorized citizens to arrest other citizens in certain specifically defined situations, including in relation to a property offense. The critical aspect of the existing law is that a citizen may only arrest a person they find committing a property-related offense at that very moment. An arrest made at a point later is not an unlawful arrest, and the arresting person is therefore potentially liable to be criminally prosecuted for any of their actions that otherwise constitute an offense, such as an assault against the suspect. We know that sometimes this is not possible, and so to avoid the unfairness of the law treating as criminal the citizen who arrests another shortly after the crime was observed, Bill C-26 would modify the current law to allow the arrest within a reasonable time of that offense. I know that the committee did consider several motions to amend the bill to add additional limitations intended to prevent this sort of conduct. The committee did not agree to these proposals. This does not mean that our government does not share the concern. Rather, it means that we are confident that the proposals in the bill will not be construed or applied in this manner. The extended time in which an arrest can be made is not unlimited. It must be reasonable. This allows all, indeed requires the court to inquire into the many relevant considerations. Most important among these will be the reason for the delay. The court may also inquire as to whether the delay had any particular detrimental impact on the arrested person. Another relevant consideration will be the purpose of the law itself. In this context, the courts will be mindful that this is a novel extension of an arrest power that is currently very limited. In interpreting it contextually, the courts are in a position to constrain the extension in a manner that accords with its purpose. Whenever the court finds that the reason for a delay in making an arrest were inappropriate or otherwise unreasonable, or that the delay caused an injustice to the arrested person, or that it did not accord with the purpose of the law, the arrest can be found to be unlawful. Furthermore, our government's confidence is bolstered by a safeguard that accompanies the expanded arrest power, which will further serve to limit the potential for abuse. This safeguard is a requirement that before the citizen makes the arrest, he or she must reasonably believe that it is not feasible in the circumstances for a peace officer to make the arrest instead. In other words, if an arrest is intentionally delayed for some particular purpose, it will be much more likely that the police should be called to the scene and make the arrest. If the police are not called and the arrest is made later, that arrest may be found unlawful on the basis that the arresting person could not reasonably have believed that the police were not able to respond. Taken together, Madam Speaker, our government is confident that these are reasonable and responsible amendments and that they should not unduly jeopardize the safety of Canadians. We urge all members to support them. I will now speak briefly on the issue of the defense of person and property. While the citizens' arrest reforms are fairly straightforward, even if they are somewhat controversial, the change to the defenses of person and property are more fundamental in that they completely replace the existing legal provisions with new and simpler ones. The necessity to reform these defenses stems from the fact that they are currently worded in an extremely complex and convoluted manner. Our self-defense laws, in particular, have been subject to decades of criticism by the judiciary, including the Supreme Court of Canada, trial counsel, criminal law academics, bar associations, and the law reform bodies. Criticism has focused on the fact that the existing law is confusing and difficult to apply in practice. It is fair to say that the reform in this area is long overdue. When the law which sets out the rules for emergency defensive action are confusing, we fail in our responsibility to adequately inform Canadians of their rights. Unclear laws can obviously complicate and frustrate the charging decisions of the police, who themselves may have difficulty reading the criminal code and understanding what is permitted. It is also extremely important. Self-defense can be raised by a person charged with murder. Self-preservation is perhaps the most fundamental entitlement any citizen may have, even more fundamental than the protection of one's property. It is essential that Parliament gets law reform in this area right. Bill C-26 proposes a single new self-defense and a defense of property provision that would be much simpler than the existing law, which provides for multiple variations of each defense depending on slightly different circumstances. The proposed new defenses would reduce the existing law into its most fundamental elements, elements which are consistent no matter what the particularities of the situation are. We no longer need different rules for different circumstances. We only need one rule that is capable of being understood and applied in all situations. I'll now speak briefly as to the issue of the defense of the person. According to the proposed new law for defense of the person, Madam Speaker, a person would be protected from criminal responsibility if the following three conditions are met. They reasonably believe that they or another person are being threatened with force. They act for the purpose of defending themselves or other persons from that force. And thirdly, their actions are reasonable in the circumstances. These are clearly appropriate elements for a new self-defense law. To be exonerated from a crime, a person should first have a reasonable apprehension of some kind of force. Second, their actions should be motivated by a defensive purpose. Self-defense is not a disguise for what is really revenge, for instance. Thirdly, whatever their actions are taken, if they're taken for a defensive purpose and in response to a reasonable apprehension of force, those actions should be judged to fall within the range of what a reasonable person would have done. Most cases likely succeed or fail on the question whether the actions were reasonable in the circumstances. This determination will be guided by unique facts and circumstances of each individual case. However, without limiting the nature and scope of factors that could be taken into account, the legislation does try to set out some of the more familiar and important considerations in a non-exhaustive list of factors. This list accomplishes several purposes. It is intended to signal to the judges that existing jurisprudence should continue to apply, even though the elements of self-defense have been simplified. It should also assist judges in their duty to instruct juries about how to apply the law in a given case. One of the most important type of factors has to do with an abusive, intimate relationship between the parties to a confrontation. The Watershed Supreme Court of Canada decision in Lavallee in 1990 acknowledged the difficulties that juries can have in finding the behavior of a battered spouse to be reasonable. In particular, judges may not understand how a battered partner might stay in an abusive relationship or how they might come to predict future violence based on past experiences. If the jury does not understand how a person in an abusive situation can come to view their options, they are more likely to find their actions unreasonable and deny them a defense. But in the Lavallee case, the Supreme Court of Canada held that expert evidence can be called to provide an explanation as to why an accused did not flee when he or she perceived his life or her life to be in danger. In this way, the evidence can also assist the jury in assessing the reasonableness of the accused's belief both about the danger that he or she faced and the need to act as he or she did. This type of case does not arrive often, but sensitivity to these situations is crucial. For this reason, the history of the relationship between the parties, including whether there were prior acts of violence, is a factor that is specified in the law as a relevant factor in the determination of whether the accused's actions were reasonable. Other critical relevant factors also include the nature of the threat and the response to it. So, for instance, was the attacker threatening to break a finger or to kill? Whether any weapons were present, the relative physical abilities of the parties, such as their age, size, and genders. So naturally, a petite elderly woman and a fit young man may have different options available to them to respond to the same threat. Madam Speaker, as part of its comprehensive study of the bill, the Justice and Human Rights Committee found that the list of factors could be improved in certain ways. They agreed to several amendments to this subsection of the legislation, all of which our government is in agreement with. The first change was to the opening words of the provision. The original words read, "In determining whether the act committed is reasonable in the circumstance, the court may consider among other factors." The committee agreed to change these opening words to say, "In determining whether the act committed is reasonable in the circumstances, the court shall consider the reasonable circumstances of the person, the other parties, and the act, including but not limited to the following factors." This change has several effects. First, it makes it clear that it is obligatory, not permissive, for the court to consider all relevant circumstances. This is an improvement in clarity. Second, it highlights critical factors, namely the circumstances of the accused who is claiming self-defense, the other party, and the act itself. Our government appreciates the additional clarity. The committee made a change to the wording of one of the factors. Factor E originally identified the size, age, and gender of the parties to the incident. The committee agreed that the relative size, age, and gender of the parties may often be relevant in determining whether one person's actions in self-defense were reasonable. However, based on representations from the Canadian Bar Association, the committee concluded that these factors will not always be determinative of physical ability. In an effort to be more clear, they amended this factor so that it now reads E, the size, age, and gender and physical capabilities of the parties to the incident. Once again, the government agrees with this additional clarity. The committee made one final change to the list of factors. They agreed to add a new factor, namely any history of interaction or communication between the parties to that incident. I've already spoken to the factor that speaks to the history of any relationship between the parties. The committee felt that this factor could well be interpreted narrowly to apply to long-standing intimate relationships and so might not capture interactions that are more casual or infrequent or may involve any single incident, such as a single threatening email. The committee added the new factor to address this type of situation. Again, on the issue of defensive property, the proposed new defensive property would adopt the same basic structure as self-defense. All of the existing provisions would be replaced with a single general test for defensive property that captures its essential components while maintaining the same level of protection as the current law. The essential elements of the defensive property would be: 1. The defender must reasonably perceive that someone else is about to or has just done one of the following: enter the property without being legally entitled to do, or take, damage, or destroy property. Secondly, the defender must act for the purpose of preventing or stopping the interference with property. And thirdly and lastly, the actions they take must be reasonable in the circumstance. A precondition for the defense is that the property must be in the peaceful possession of the person when the interference takes place. This term is part of the current law and will be maintained in the new law. It has been interpreted by our courts to mean that the defender of the property must be in actual physical possession of or control over the property at the time of the threat or interference, and that the possession itself must be unlikely to lead to a breach of peace and is not contested by others. This is the way in which possession must be peaceful. It must not be contested or risk of violence or public disorder. In closing, Madam Speaker, Bill C-26 clarifies and expands certain provisions which authorize Canadian citizens to undertake actions that would otherwise be prohibited where there is a real emergency involving either threat to property they possess or to the safety of persons. It strikes the right balance between discouraging crime and confrontation on the one hand, and permitting Canadians to defend their basic interests where no other options are available. I urge all members to support this bill. The reforms are long overdue and represent a principled and measured response to complex situations. Thank you, Madam Speaker.
Questions and comments. L'honorable député de Gatineau.
Merci, Madame la Présidente. Je remercie mon collègue, le secrétaire parlementaire au ministre de la Justice. Siégeant au même comité que mon collègue, j'ai effectivement apprécié le travail de collaboration entre les différents membres du comité et j'aimerais poser la question suivante. On sait que l'Association du barreau canadien, le barreau du Québec, différents intervenants avaient certaines inquiétudes en ce qui concerne l'équilibre entre les critères objectifs et subjectifs. Et j'aimerais demander aux députés s'ils croient que les amendements qui ont été apportés et les textes tels que rédigés répondent à ces interrogations par les différents spécialistes en droit qui sont passés devant le comité.
L'honorable secrétaire parlementaire.
Merci, honorable membre, pour cette question. C'est drôlement une question pertinente parce que ça fait partie énormément du débat qu'on a eu lors du débat du comité. De ce côté de la Chambre, nous sommes convaincus qu'il y a un bon équilibre entre les critères objectifs et subjectifs. Évidemment, il n'y a aucun scénario, il n'y a aucun droit qui est parfait. Mais évidemment, au Canada, on a le judiciaire le plus reconnu, le plus capable qu'il y a probablement dans le monde en entier. Alors, pour ces raisons-là, l'interprétation judiciaire qui aura lieu dans ces causes ici, on est confiant, arrivera aux bonnes décisions et protégera les intéressés.
Questions and comments. The honourable member for Winnipeg North.
Yes, thank you. Madam Speaker, I'm wondering if the member, and I believe that there has actually fairly good support from all members of the House, maybe with the exception of a few. I know that there was some concern that was raised as the potential costs of implementation of this particular bill. In particular, I understand there was some concern from provinces, and I'm wondering if the member can provide to the House some sort of a comment in terms of to what degree provincial jurisdictions were involved in any sort of dialogue or discussions when the government ultimately brought forward this bill.
L'honorable secrétaire parlementaire du ministre de la Justice.
Well, the issue of cost is always one that's close to the government, obviously. However, it's our position that the cost with regards to this bill, if anything, will be diminished because based on clear instruction to jury, I think the number of possible prosecutions may be limited because as the law now stands, many of the prosecutors, many of the police who lay the charges are uncertain as to whether or not there should be a charge. And rather than take the chance, in the law as it stands, they put the case before the court, and of course this clogs the dockets. With the new amendments to the law, there will be much more clarity, Madam Speaker, and for that reason, there will most probably be fewer cases that will go before the court as a result of uncertainty as what the real rules are. This is amendments that actually help not only the citizens, it helps the prosecutors and the police, and it's our feeling that if anything, costs will be diminished because clarity of the law will unclog the dockets.
Questions and comments. The honourable member for Saanich and the Islands.
Thank you, Madam Speaker, and I thank my honourable friend for his presentation of Bill C-26. I think some members of the House will know that I had hoped to present an amendment to the bill this morning to deal with this section that it's dealing with citizens' arrests and creating the new possibility of arrest within a reasonable time, in quotes. This is Section 35(3) of C-26, which would seek to amend the existing criminal code, Section 494, subsection 2. My question is on this specific point, and the concern shared by many, but particularly put forward to committee from the Canadian Bar Association, that this opens the door to potentially a greater role for private security forces instead of the police, that it creates the opportunity for people to go after someone long after the event. How is the average citizen to know what a reasonable time is? And that this actually opens C-26 to considerable abuse. And I'd ask my honourable friend why it was that we couldn't have deleted this one section that really opens the door to some mischief that isn't necessary for the overall purpose of the Act.
The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Madam Speaker. Well, first and foremost, I mean, there always has been a concern with vigilantism, and the issue of reasonable time is there because in certain circumstances the police cannot react rapidly because of certainly either because of distance or where the incidents happen, or possibly responding to other emergency situations. But what one's got to remember is, first and foremost, the #1 responder to situations of crime will remain the police. And no citizen's arrest will be deemed reasonable unless it was, in the person's mind, not possible for the police to respond in a timely fashion. And as I've said once before, listen, we have probably the best judiciary in the world, and they certainly will not struggle with the issue of what is reasonable time given the circumstances of one particular event.
Questions and comments? Questions et commentaires? Reprise du débat. L'honorable